Good morning and welcome to an oral argument session of the 5th District Court of Appeal. I'm Judge Sasso and I have with me Judges Traver and Judge Neighborhouse. We are hearing our third case of the day. It is case number 20-1199 McIntosh Fish Camp and Susan G. Monroe versus Martin Caldwell et al. We are being recorded on YouTube and live streamed. In terms of rebuttal time, we'll reserve 5 minutes unless we hear from you to the contrary, appellant. And with that, you may proceed.
Thank you, Your Honor. May it please the court, Mark Albrecht for the appellants. This is an appeal of the trial court's grant of summary judgment of the appellant's amended counterclaim based on caveat emptor grounds. The trial court based its granting of the motion on Billington versus Ginn Lapine Island Limited, which is a Florida appellate case out of your district here from 2016. Our argument is that the trial court's granting of the appellee's motion for summary judgment and the dismissal of the amended counterclaim were error on factual and legal grounds. We submitted briefs outlining various grounds, but I wanted to discuss today our position that the Billington case is factually and legally distinguishable from this case. This court in Billington was concerned about claims based upon representations allegedly made outside of the contract. On the other hand, the claims made by the appellants in this case in the amended counterclaim are based on the contract for sale and purchase itself. The appellees also used Wise versus Cherry, which is a 3rd District Court of case out of 1985, 477 Southern 2nd 12. In their argument to support the motion for summary judgment, Wise is similar to Billington and is distinguishable as well. In particular, in the Wise contract, the court noted that nothing said that the property was suitable for, quote, sit down, close quote, restaurants. On the other hand, in this case, the contract that is involved here says that the property is being sold for a fish camp, RV park, mobile home park, and residence. The contract in this case is clear that the transaction involved the sale of a commercial property meaning that it was meant to be able to earn money for the owners. The contract also specified that it was a sale of a working fish camp, RV park, mobile home park. The appellees presented the property as a working fish camp, RV park, and mobile home park. So pursuant to the contract, they were obligated to convey that specifically described property to the buyer, but it turned out that they did not convey the property that was described in the contract. And that's the gist of the allegations here.
What contractual provision are you relying on to support your statement that that is specified in the contract?
I believe it's paragraph 6 of the contract lays out the specifics of the what's involved here. And that obviously is attached to the record at page 134.
Okay.
Because it says, I'm sorry.
Go ahead.
Because it says that it was obligated, that the intended purpose was to convey a property that was, and I'm quoting right out of the contract, was free of liens, but subject to existing zoning and governmental regulations, provided there exists at closing no violation of the foregoing, and none of them prevents buyers' intended use of the property as a fish camp, RV park, mobile home park, residence. And that's in 134 in the record. The fact that
does that support an argument that the property intended to be conveyed to be used as a a recreational vehicle park or specific, a park that includes, a specific amount of mobile homes or a specific amount of recreational vehicles with a specific septic tank capacity, et cetera?
Well, it was an as-is contract, which means, you know, it stands as it is, and she was given the opportunity to inspect. And when she went out to inspect, she found that the property contained the sites that they advertised. There was advertised as 8 mobile home sites, a 2-story concrete building residence, and 6 RV spaces, and that's what she found when she got out there, and that's what they purported to sell.
Let me ask you a little bit about the inspection component, because we have some questions on that. First, just as a general legal matter, appellant, I think this might be, sorry, I can't recall whose brief this is cited in, but the Trans Capital Bank versus Shadowbrook case, it's a 4th DCA case from 2007, which stands for the proposition that in a commercial transaction, even if the defendants misrepresented aspects about the property, that misrepresentation is not actual unless they resorted to some fraudulent means in preventing a prospective purchaser from making an examination of the property. First, would you agree that that's an accurate statement of law?
I would agree with that statement of law.
Okay, and so what here factually do you think happened to preclude an examination of the property? I just want to make sure I have all those facts.
In her affidavit, she asserted that while she was given the opportunity to inspect, she later found out after she had purchased the property that some of the tenants on the property had been threatened to not speak to her, so she was unable to talk to them, and then she was prohibited on the same basis from examining some of the interiors of the mobile homes that were there. She was led to believe that everything was by the appellees and the realtor, that everything was good. But not only that, she at one point said, well, maybe I should get my own realtor and or attorney involved, and she was persuaded by them not to do that. And so she was relying upon, based on a relationship that had been developed in that time, on the representations of the sellers and the realtor. But that also ties into the language of this contract, which I discussed.
Let me follow up on that real quick. As to the threatening to speak with the tenants and being prohibited from examining the interiors of 3 trailers, what evidence in the record is there to establish that that was material to her decision to enter into the contract?
Well, she states that if she had been aware, the bottom line is that this involves a situation being able to have a septic system that can handle the sites. And that ultimately is the issue here, because it's been determined that that septic system is wholly inadequate to handle all of those sites, even though they had promoted to her and provided her with information that that septic system had been upgraded by a local servicer who was supposedly the most reputable and well-known in the area. So,
and focusing specifically on the septic system, in light of that principle of law that we've just discussed, that even if there's a misrepresentation, that there needs to be a showing that the defendants resorted to some fraudulent means in preventing an examination of the property. What fraudulent means were used to prevent examination of the septic system? Well,
she noted some issues. She brought them up to the realtor and the appellees. They basically told her there's nothing to worry about. It's either an overflow of the laundry system at this time because it was being heavily used, or there was problems with the pool leaking. And you're talking about, trying to determine the adequacy or the ability of a septic system to handle the work. So the problem is doesn't that kind of turn the rule on its head, though? If a misrepresentation is only actionable to the extent the defendant also took fraudulent means in preventing a prospective purchaser from making an examination, wouldn't that suggest that the fraudulent being prohibited from an examination has to be something other than a mere misrepresentation? Well, except that in this contract as well, there's a provision, language at record 139 that says buyer agrees to rely solely on seller, professional inspectors, and governmental agencies for verification of the property condition, square footage, and facts materially affect the value. So their argument has been that that doesn't apply to us because that's in a provision that grants the realtor indemnity, if you will, or protection against his representations. But, you know, as we know, things are put in contracts for a reason. And this language is put in here, I think, in light of decisions such as Bassett and some of the others that talk about sellers, even in a caveat emptor situation, not being allowed to engage in active misrepresentation, active concealment, and efforts to prevent the buyer from determining the truth about the condition. Not only that, we've got allegations in her affidavit and in her complaint, amended complaint, that she specifically asked these questions of them. They responded and gave her answers, and the rule and the principles are that if the seller doesn't have to speak, but if they're going to speak, they have to speak truthfully. And her allegations are that they did not. They misled her regarding all of that with the intention of getting her into the contract. And then even though they, you know, so they made these statements, and her position is they didn't speak truthfully about that. They concealed and they hid the condition specifically. Now, they were absentee owners, landlords, but they had been running this park since at least 2011. It had been in the family even before that. So she asked the questions, they provided her answers. They also provided her some documentation, which supposedly supported their position that there are no problems here. She also checked with the local authorities, Department of Health in the city, to see if there were any issues with any of the property, and was told there were none. In fact, her only information was that there was problems with the camp that was next door, another fish camp. So she's getting all this information, trying to find out, you know, the truth of it, and being told certain things and being provided certain things that basically say there's no problems here. There's nothing to worry about. Everything's good. The septic system's fine. It's upgraded. We have the best guy in the area do it. Then she comes to find out afterwards that not only is it inadequate, but it may be an illegal installation. So
you mentioned at the beginning of your argument a couple of cases that the trial court relied on in entering summary judgment. You didn't mention a third, which is a 1939 case from the Supreme Court called Cassara.
Yeah.
Our court in the past has struggled with how to reconcile Cassara and Oceanic Villas, which happened 2 years later. How do we reconcile that holding in Cassara with the validity of merger clauses as it relates to barring fraudulent inducement claims?
Well, I think the part of the problem is you've got, and this is what I've struggled with as well, and in the whole process, you've got a contract that says certain things, and it's a commercial contract, and we've got the caveat emptor principle, but the caveat emptor principle is not bulletproof. It's not strict liability, because there are exceptions that have been laid out by the court, and I believe in our case all three of those apply. But not only that, you've got the interplay of you know, we want to have contracts stand up, but then you've got the principle of the making of the contract, which is the mutuality, and we have a meeting of the minds, along with the idea that people can act badly and do wrongdoing. So we have a policy that says you can't benefit from your wrongdoing. So you've got to play all three of those together, and that's one of the things I've struggled with. That's why I'm in this case, because of the way the court entered the ruling, I'm arguing that there's a great distinction here, because that contract in Billington had language in it that, you know, waived all claims to the from the buyer specifically. This one does not have that kind of language, which is the language I just quoted, where you've got language which I believe arises out of Bissett and the other cases that talk about you can't you can't mislead, you can't actively mislead. And this contract is the FAR contract, the Florida Association of Realtors contract. So it obviously has to be somewhat fair, I would say. You can't be so one-sided as to make it unconscionable. So I think this language in here, along with the concepts that we've discussed, as far as the distinction in the facts, as well as the policy against fraud, gives, I believe, I submit, the right of the
You're muted now. And you're also into your rebuttal, so if you want to wrap up and reserve.
Yeah, so my argument, like I said, she's now down to 4 sites is all she can use because of the governmental regulations. Obviously inadequate. There were originally like 14 sites there, so she did not get what she contracted for. So I would submit that the court's ruling in this case was error, that it should be reversed and remanded for a trial on the merits. Thank you.
Thank you. Callaway?
May the police court, I'm Lawrence Callaway of the firm of Klein & Klein LLC. We represent the appellants, the appellees, Martin and Mark Caldwell. It's clear that the trial court's entry of summary judgment with respect to the amended counterclaim was proper and should be sustained on appeal. As explained,
address specifically the facts that we just talked about, and how the written contract specifically contradicts the allegation that she was precluded from inspecting the interior of 3 trailers, that the tenants were intimidated from speaking with her, and that she was dissuaded from getting her own attorney and a realtor.
Well, going back to Billington, the contract provided that the rights and obligations were to be found solely within the 4 corners of the written contract, and that any changes to those rights or obligations had to be in writing and signed by the parties in order to be enforceable. Under the terms of the contract, the sellers made no warranties other than marketability of title, and the buyer had 15 days to make whatever inspections or investigations he wanted with respect to the property being purchased and sold.
So is it your argument that anytime there is a merger clause in a contract, there is no claim, there can be no claim for fraudulent inducement?
Not in the case of a general merger clause, but in this situation, Your Honor, we had a specific disclaimer of any warranties other than marketability of title. And we had a specific provision that if the buyer, they gave the buyer the right to do a 15 days inspection. And if they found anything that they found a discrepancy or the unacceptable, they had to give notice to the seller. But if they failed to give any notice to the seller of any problems, then that would be deemed an acceptance of the property in its as-is condition and a waiver of any claim by the purchaser.
In a set of circumstances, even with those provisions, if there was facts establishing that the purchaser was prohibited from making an inspection due to fraudulent means, do you think that might give rise to a fraudulent inducement claim? Not asking you to concede that that's the set of circumstances here, just as a general legal principle that could give rise to a claim.
If under certain contracts, that's possible here. But in this case, Your Honor, the buyer had the opportunity, if she felt that she had been precluded from making any inspections or had believed that there were certain representations made either prior to the signing of the contract or during the inspection period, she could have either demanded that those be added to the contract, and if refused, demand her deposit back and walk away. There were several outs provided for the buyer in this situation she did not take advantage of. Again, this is
what about the specific allegation that the tenants were basically bullied into not talking to her. So something that wouldn't have come to her attention in the inspection period wouldn't necessarily to be able to rely on any of the provisions that you've cited so far to cure that issue, if that's something that would actually make a difference. So why isn't that allegation relevant to a claim for fraudulent inducement?
Well, the question is, Your Honor, that you're looking at allegations regarding a septic system, which is a physical situation on the property, has nothing to do with a tenant or whether they got inside of a mobile home or any particular residence. There's no evidence and there's no allegation that they were anyway ever stopped from coming onto the property. And if she had, believe that she had the every right to demand access or return of her deposit.
So in other words, even if she was, and even if the tenants didn't talk to her because of some intimidation, that's not material to the deal.
Not material. I'm sorry, not material to the issues here. The issue in this situation is a septic system that the purchaser believes he was represented to have, and there's nothing to stop them from looking at the septic system.
So as to the septic, go ahead, Judge Fravor.
In the TransCapital case that we've been talking about, there are a series of exceptions that are laid out as it relates to the caveat emptor doctrine. As it relates to the septic system, I want to ask you about the third that's outlined in that particular opinion, which is where a party undertakes to disclose facts and fails to disclose the whole truth. Is it a fair statement or characterization of the counter affidavit that on several instances as it relates to septic issues on the property, that is precisely the situation that's alleged?
That's what's alleged, Your Honor. Yes, that's correct. But again,
if that's the case, and we're on a summary judgment standard, and it's the old standard, it's not the new one that's going to come in place in a month and a half or so. How doesn't that create a factual issue that needs to be resolved at trial?
Well, if I understand Billington properly, the issue is whether or not the allegations are precluded from being asserted, not whether the allegation or the events alleged occurred. We're dealing with the interpretation of the contract, which is a proper issue for a summary judgment. Question is not whether or not there was fraud, but whether the claims for fraud are precluded by the agreement of the parties.
So I guess this expands a little bit on Judge Sasso's question from earlier, but it's your contention then that even though this is a 7 or 8 word merger clause, that in combination with the as is paragraph, that gets you where you need to be. Are you viewing that combination of things in total as a non-reliance clause, or are you viewing it as something different?
It's kind of a combination of a merger and a non-reliance clause, because at the end of the provisions, it says that if they don't give notice, they're deemed to have accepted the property as is and waived. So not only do you have start off with that there is the affirmation or the acknowledgement that the seller makes no warranties other than marketability of title, but the buyer then acknowledges at the close of all the provisions that we're relying upon that if they don't object to the condition of the property, then the buyer is waiving any claims or waiving any reliance. So it's kind of a encompassing all of the possibilities. When you look at Billington, they talk about waiver, non-reliance, and disclaimer, and we're kind of in a combination of all those here.
If I agree with you and we view it that way as kind of a combination of all three of the issues, how do we view there being a waiver of fraud claims in this contract if it doesn't specifically mention waiving fraud?
The language in the contracts in Billington and also the other cases we've talked about simply said that there are no other representations or warranties. Here we have a combination of the buyer up front. There's the representation, or there's a statement there are no warranties other than marketability of title, and then there's a provision, express provision waiver of any claim of defect at the end. So if the buyer believed that there was a representation made or there were conditions critical to their decision to move forward, they could have at that point demanded those be added in writing to the contract. However, if the seller refused to do so, receive return of their deposit. But in failing to do so, they, by the terms of the contract, waived any claim for defects. You know, the parties to a contract are free and able to address or allocate risk between them, the parties, and that's exactly what they did here. And there were very different opportunities for the buyer in this case. If she did not feel that she had the right to, or had the inspection that she needed, or she felt there were representations that were critical to her, if she, you know, she could have, as the court in Bellington said, appreciate the gravity of the negotiation process and made sure that those conditions were included within the four corners of the contract. She chose not to do that, so by the terms of the contract, she waived any claim for defect, whether it was stated or not.
And what of the allegation that you know, the property was conveyed without permitting, and the contract specifically calls for a property being conveyed that is in compliance with all regulations?
The contract provides that the buyer is supposed to take or has the burden of doing all inspections, including all government regulations, inspections, permits, availability, whatever. And that is in section 7 of the contract. So it's the obligation of the buyer to bring any deficiencies that the buyer feels or finds or discovers to the attention of the seller in order to correct. Under the express terms of the contract, if the buyer does not do that, he waives those defects. It's not the obligation of the seller to go out and disclose or to do the inspections for them. It's just the situation is that the buyer has to do the inspections. If there are conditions that she discovers, then she has to bring those to the attention of the seller. And this, but if she does not bring those to the attention of the seller, she's waived those defects. Again, now the buyer or the appellant has relied heavily on Schottenstein and Bassett versus Bassnet. Again, as pointed out by the trial court in its ruling, there's nothing to indicate that any contract like that it appears or that we're dealing with in this case was present in either one of those cases. The situation we're talking about with respect to the inspections are similar to those that are provided in the contract with respect to, for example, title. The buyer is or the seller is obligated to deliver marketable title, but the buyer has a certain amount of time within which to perform an inspection as to the condition of title. If he doesn't raise any objections within that time, he accepts title as is and waives any claim for defect. Same thing with survey. If the surveyor has a certain amount of time within which to do a survey of the property, and if there are any defects discovered, then he brings those to the attention of the seller, and the seller has an obligation to take care of those. If he doesn't make an objection, then he waives those defects. Similar situation, the availability of permits and governmental approvals is expressly listed as items to which the buyer is to perform inspections during the inspection period under section 7 of the contract. If the buyer does not do an inspection, or if the buyer does not raise any defects under the expressed language of Section 7, then he is deemed to accept the property as is, however it may be, and waive any claim for defect against the seller. Do you have any, does the court have any further questions?
No, thank you for your argument.
Thank you.
All right, in rebuttal, one of the issues here is the contract itself. And what does the contract say? As we know, the contract has to be interpreted in its total. Our position is that the court has ignored some of the provisions that benefited the appellants. In particular, the provision that I cited, which is on record page 139, that last sentence in that bolded, highlighted, all caps, talks about the buyer being able to relying solely on the sellers, governmental entities, professionals to determine or to be able to determine the condition of the property and anything that might materially affect its value. Our allegations in the amended complaint and in the affidavit point to the fact that she was persuaded or led to believe that she could rely on that information. She did her own inspection. She did her own attempt to locate information with the governmental authorities. Ultimately, was convinced that there was no problem with the septic system, none whatsoever. However, I don't know how you overcome that unless you get in there and start digging up septic systems, which would be a cost way beyond what would be required. Not only that, we have the situation where in the Bissett, they cited to reinstatement second 540 and 541. And that does provide that there is some obligation to inspect, but there's limits on it. And then the limits are also on the misrepresentation that you cannot, which is where we get the provision, the principle that the misrepresenter should not be able to benefit from their wrong doing. So basically our position is that we've made allegations that support the claims that there was wrongdoing, there was fraud in the inducement, there was the other issues involved, that the court should have looked at those, particularly in light of the contract provisions, and basically ignored the ones that benefited the appellants. And so under those circumstances, with the facts as they are in the record, the court erred in granting summary judgment and dismissing final judgment on the amended counterclaim. Thank you.
Thank you both for your argument. We'll be in recess.